Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
All right, Ashley, I appreciate that. Thank you. Some of you out there I know me. Some of you we work together. Some of you don't. My name is Dan Wasserstein. I'm an association attorney. All I do is represent associations. It's 100% of our practice, me and 3 other lawyers here, and we represent over 300 communities, primarily in the South Florida area, but also Jacksonville, St. Augustine, and the West Coast as well. I'm licensed by the state to give this course today to property managers, but it's also informational if you're just board members. For property managers, you will get 2 CEU credits, so it is important to get Ashley your information. And for board members, it's just informational for you, and it's good information. This is probably one of our most popular presentations that we do. Because every association has questions about how do we do the violation and fining process, and the statutes changed over the years. So this is a good overview for anyone that needs some insight into that. So I'm going to share my screen. And here, let me do that. Share the screen. All right, and then we'll start. And hopefully everyone can see that. Ashley, can you confirm that you can see
I can see it.
all right, very good. We're off. All right. So we'll go right into it. The first part here is really just explaining what governs associations. What are things that people can violate? And it says here, as you can see, that all the owners, tenants, and guests have to comply with the Florida statutes, of course, federal law as well, the declaration, the bylaws, the rules and regulations. You also have articles of incorporation, but those don't really have rules about how people will behave themselves or obligations. The articles are more about just setup of the original corporation with the state of Florida. So we usually don't really see articles being something that owners violate for that reason. But yeah, and it's not just owners. I said owners a moment ago, but it's all these other people, tenants and guests too. Owners are going to be responsible for the behavior of those people. So they don't get a free pass because obviously tenants and guests, they come, they go. And in the interim, if they're disruptive to your community, there's no real retribution by going after them because they're here today and gone tomorrow. But unit owners have a vested interest. They have a financial interest. So those are the people that predominantly you're going to want to enforce against when anyone is misbehaving with association with that owner. Now, some examples of what are some of the most common provisions that we see that owners, tenants, or guests violate. What are some of those things? Of course, architectural standards and alterations when we're talking about an HOA, especially when people make changes to their driveway or their color of their home, things like that. Usually the documents require the owner to get pre-approval of it. I'm dealing with it myself right now. I had to submit paperwork to my HOA for my house. We were doing a generator and we can't just put it in. They require that we go through this architectural process. And if I didn't go through that, they would be in the right to put me in violation. Pet restrictions, that's a popular one. Of course, you know, we have some communities that don't allow pets at all. Some communities limit what types of pets or the size of them or the number of them. And we all know, of course, that there are ways that owners circumvent them with emotional support animals or service animals. You know, there are legitimate versions of those, of course, but we see a lot of abuse. So, but nonetheless, you do have pet restrictions that exist in a lot of your documents. for those animals. And of course, everyone should know that even if they have an emotional support animal or a service dog, even though some of your restrictions go out the window, they still have to clean up after that animal. They have to keep it on a leash, and it can't be a nuisance by barking or attacking people or other animals. So you can still enforce some of your restrictions on those support or service animals and put those people into the violation process. We had one, about a year ago, it started with a dog that was an emotional support animal that was excessively barking. We got affidavits from the neighbors, and we just, as of about a month ago, got a judgment that owner had to remove that animal. We also, in the interim, were, the association was pursuing violations and fining. So again, those animals are a big source of violations. Restrictions on leasing and sales of homes or units, that's a big one. A lot of times it'll say in the documents that owners need to get prior approval before they can lease or sell the property. And a lot of times they don't do it. They just sell it. That's a violation. And there's certainly other types of leasing violations that can happen, premature occupancy, people misbehaving while they're leasing, if you require a security deposit and they don't pay it, all sorts of things. Parking and vehicular restrictions. And, one of the most common ones, nuisance and noise complaints. That's probably one of the biggest ones we get, where owners will go to folks like you guys, board members or managers, and say, hey, the neighbor is driving me crazy. Their television's too loud. They're fighting with each other. They are, they're playing a musical instrument at 1 a.m. They're having parties. And if it does rise to the level of a legal nuisance that any ordinary other person would find objectionable, those are things where it's a violation that's enforced against as well. So those are some of the most common ones that we see, especially as lawyers, violations of the documents. So now we've talked about sort of what you can enforce and what are some of the things that are most commonly enforced. All right, well, how do we go through enforcement, and what is the process, and who does it? Now, as to who does it, the association through the board is charged with the responsibility of uniformly enforcing the governing documents. And I'll stress the importance of the word uniformly there. And we'll talk about this at the end when I get to what's the most important slide of the whole presentation. But uniformity in applying your rules and your restrictions and how you issue violations and enforce against them is extremely important, because there's something I'm sure a lot of you have heard of called selective enforcement. And we'll talk about that more later, but that can create a defense even when someone is absolutely in the wrong. If you treat them differently, then you may not be able to proceed. And of course, then you have another issue with enforcement, the failure to enforce in a timely manner. And again, we'll talk about that at the end, but that's where you're thinking of statute of limitations or waiver arguments, things like that. As far as the condominiums, those have their fining provisions found in 718-303. It says the association has the authority to fine, and it lists all the different people for failure to comply with the governing documents. Now, the authority to fine arguably doesn't have to be in the governing documents, but if your documents are silent on fining, I would still strongly advise that you amend your rules and regulations simply to say that the association has the authority to fine any of the above people, owners, guests, tenants, etc., in accordance, you could just say in accordance with the statute, with 718-303, or if you're in an HOA, 720-305, same exact thing. And that's what I'm showing you now here, the HOA statute, same exact language in this regard, as far as who can be enforced against. And again, the authority doesn't necessarily have to be in your documents, but if an owner comes in and says, show me in the documents where it says you can fine me, it's much better to say, here it is in the rules and regulations, that we rely on the statute and, to defer to that for fining, rather than to simply say, well, it doesn't exist, but our lawyer told us we can do it. It's a lot of times it goes a long way to just show your owners and your residents in black and white that this is in your paperwork. So now we're really getting into the process. Okay, so how do we enforce? Who do we enforce against? Okay, how does it start? And it starts with a potential violation is brought to the attention of the association, and it can be by a multitude of people. It can be management. You have management sometimes that is circling the property, walking the property. You may have third parties that are examining the property for management, and they may flag issues where an owner has something on their property that they shouldn't have, or in a condo they have a balcony they're treating as a storage facility with junk instead of having what's legally allowed to be there. You also have, of course, unit owners, and that's probably the number one way that we become aware of violations, is because people tell on each other. They go to the management company or the board and they say, hey, so-and-so they have a truck they're not allowed to have, or they're parking somewhere they shouldn't be, or they have a pet they shouldn't have, or whatever. And of course, it can also be tenants that report these things, board members, which of course they are unit owners too, and then committee members. Sometimes you may have a committee that's tasked with walking or examining the community for these things. So any one of those people bring the information. It should be gathered and reviewed by management or by the board initially, or a combination of both. A violation notice will usually be sent to the offending party, identifying their behavior and the covenant or the rule it violates. Now, again, you don't have to send this, I call it a violation notice or a warning notice, but I believe 99.9% of associations do. And they'll say, hey, we've reviewed this issue. We find, it looks like this is legitimate. This is the problem. And, very short, brief statement. Here's the section of the documents that it violates. And then a lot of times it'll also give them, if it's something like that wasn't an occurrence, like let's say someone had a loud party. Hey, we're going to tell them, you had a loud party. Here's the nuisance provision. Don't do it again. But if it's something that's ongoing, usually this warning notice is going to give them a window of time to fix that issue before it'll go further in this process. And I would always recommend, it's always a good idea, especially for those types of not occurrences, but situational or tangible, viewable violations, that you take a photo of it, management or whoever, so that it's irrefutable. Because we've had violation letters where people say, I didn't leave the garbage cans out overnight. I didn't park my car illegally. It wasn't me, and if we have photos, it's pretty hard for them to dispute a photo that's right embedded into the violation letter. So that's something I'd recommend. Now, again, I touched on this first bullet point here. I advise that, if the violation is a continuous one that's tangible and ongoing, then you can give them the opportunity to cure. And again, usually it's 15, 30 days, something like that. But if either it's not a continuous type of violation, or it is a continuous and it remains uncured after that window of time that they're given, then the next step would be a board meeting to determine if the board's going to impose a fine. So that happens at a properly noticed meeting. It only has to be noticed on 48 hours. And if the fine is levied against the violating party, they do not have to be there. And the board is the one who sets the dollar amount. Now, older documents may say that the committee does some of these things, that they control the dollar amount, that they hold the initial meeting, things like that. That is no longer the case and hasn't been for several years now. So it's important to follow the statutory process. So really, after you've sent that warning letter, step one after that, if it's still not resolved, is hold a board meeting. Now, one of the other questions we usually get is, well, what if we've already adopted a menu of charges that says if you leave the garbage cans out, it's 50. If you don't wash your driveway, it's 100. Why do we still need to have a board meeting? And the answer is, those set charges are just a way of making sure that when the board gets together to fine someone, as they're required to by the statute, that they do so in a uniform, and remember I said that word earlier is important, they're done in a uniform amount so that one neighbor doesn't get fined for leaving the garbage cans out for 50 and the other one gets 100. But again, just because you've adopted that schedule of fees doesn't change that under the statute, you are required to have a board meeting, because the statute says that fines, it says any fine levied by the board. And then it goes on to talk about what we'll talk about in a few minutes. And the only way the board can levy a fine is the same way it can take any other action, which is at a properly noticed meeting. And the statute was actually, the HOA statute on fining was qualified in this legislative session to reaffirm what I was just saying, which I had been saying it for years, but it reaffirms now. You have to have the board meeting. You also have to have the committee meeting as well. These are not voluntary. These are not only if the violator asks for it. These are mandatory things. So one board meeting. As I said earlier, it's a 48-hour notice. Fining's an agenda item. It's ideal to not name necessarily, but identify the units or the lots that are going to be fined. There's some arbitration case law where the arbitrators wanted to see that there was some identification as to who was going to be fined in the notice of the meeting, and especially in the minutes of the meeting. And again, at the meeting, the board will vote and they determine the dollar amount. It can be up to $100 per occurrence, or if it's ongoing, per day, up to $1,000. And if it's an HOA under statute can actually go above 1,000 max. But that's only if the association's amended its governing documents to do that. But otherwise, the board's authority is to levy a max $100 per occurrence or per day violation. And once the board's levied that fine and determine the dollar amount, that's when it goes to the committee who either approves or disapproves before that fine will be imposed. And again, this is not optional. And there were some boards who used to say, well, Dan, why do we have to hold the committee meeting? We only fined one person and they haven't asked us to hold this, give them an appeal or have a committee meeting. Why do we need to do it? And the reason, again, is because the statute says you have to. And again, that was clarified this year in the legislature that this is not optional. The statute says before a fine levied by the board can become effective, it has to be approved by this independent committee. So again, that's part of the fining process. It's not an appeal option for the owner, but rather it's a part of the process that has to be done. The party who you're seeking the fine, they have to be given at least 14 days written notice. It's got to be at least 14. There's a case where an association gave 13 days notice and they lost the entire case because they gave 13, not 14 days. So we need to strictly comply and make sure that after the board's levied the fine, that before that committee meets, that we give that person the 14-day notice. The notice has to include the date and time and location of the committee meeting. It has to include what the violation was and what provision of the governing documents it violated. And now, importantly, under the statute, it needs to also indicate how that they can resolve the underlying violation. Doesn't mean that just if they resolve it, that they now avoid the fine. You know, now that we're already this far down the road, but it does advise them how they can get that cured so that it doesn't have to continue on in violation. So you've now had the board meeting, you've sent your 14-day notice, and now you have this committee that's going to meet to determine either yes or no. The fining committee has to be at least 3 people that are not officers, directors, employees, or any family, close family, spouse, parent, child, sibling, or a director if the owner is an entity. So you have to be very careful that that none of these people are conflicting, because obviously those could be biased individuals. If the spouse of a board member is on the fining committee, it's a pretty good chance they're going to rubber stamp all the fines that their husband or wife voted on as a board member. So that's why we want some independence here, to not have that conflict. Now, look, the committee only has the authority to say yes or no. The committee cannot tweak the fine. They can't say, well, instead of 100, we'll make it 50. Or, you know what? We're going to give you more time to fix the issue. And if you fix it, then we'll revisit this or wipe away the fine or anything. All the committee can do is examine what the board did as far as a fine, what the board decided and the dollar amount, and just say yes or no. It is important that the statute says the individual's entitled to a hearing before at least 3 members. So that doesn't mean, so sometimes we've had boards say, well, one of the members is sick, but since we still have a quorum of 2 of them, can we hold the fining committee meeting? And the answer is no, because unlike a board meeting where you can get by with just a quorum of the board, the statute says that the owner's entitled to a hearing before three committee members. So if you only give them a hearing before 2 committee members, even though it may be a majority and a quorum of the committee, it still doesn't comply with what the statute says in that regard. So it's something to be mindful of, that you would want to make sure that you are actually giving them the hearing before the 3 people. Now, of course, if the committee upholds the fine, then there's no further work to be done other than to send that person a letter. And quite honestly, I recommend sending them a letter about the outcome either way that tells them that the fine was upheld or not upheld. And if it's upheld by statute, the due date is not for 5 days from the sending of that notice. So for managers and accounting people at management companies, you just want to be mindful to wait the 5 days before you tack the fine onto their ledger, because otherwise it's a premature assessment of that fine. And again, I talked about, I think, some of the comments on this slide previously, so I'm going to skip over this one here. Now, importantly, what can you do? You've got a fine, you had the board meeting, you had the committee meeting, you gave all the proper notice, the letter went out, the owner didn't pay the fine. Well, what can you do? Well, aside from filing a lawsuit for $100 or even $1,000, which is really not advisable, because all you're going to get back is a piece of paper that says they owe you $100. What else can we do? How can we wield a fine to really get it paid and leverage it to be punitive, which is, ultimately the intent, to deter this behavior? Well, in a condominium, the statute really takes the teeth out of the fine because it can never be a lien. Now, the best way that you collect your unpaid assessments are through your lien rights, because if someone doesn't pay your condo or HOA assessments, you can lien their house and you can foreclose on it. So that's a really bad penalty. No one wants to lose their house, so it gives teeth to that collection. But unfortunately, you can't do that with a fine in a condominium. You can do it in an HOA, but only if a fine is a continuous one that got to at least $1,000 max. Only if you get to that $1,000 can it become a fine. And even then, you would have to have governing documents that set forth that fines are lienable. But it is helpful. We have some clients, HOA clients, that we've done liens for fines of $1,000, and it's immensely successful in getting them collected. Otherwise, the dollars usually will sit on the account and on the ledger, because associations don't want to file lawsuits for money judgments on them. And usually they'll be collected when the owner goes to sell their property, or if they want to lease the property. That's really a good opportunity to get fines paid. But again, it doesn't, sometimes that means that you're not getting compliance. We had one guy in an association in Boynton. He would have a party till 4 a.m. every 6 months. And on the following Monday, he would walk in and hand them $100 bill and say, don't bother sending me to fining, here's the money. So the fining in that example was not a deterrent. So sometimes you do need to engage the attorney, and you need to actually get people to go before a judge and be forced into compliance. But again, we're talking about fining here today. So to that extent, what else can we do with fines besides going through a legal process to compel compliance? Well, in an HOA, you can use them as a lien. You can also suspend access to common elements, common areas, and you can suspend voting rights to anyone that's more than 90 days past due on a monetary obligation, which includes a fine. Now, look, a lot of times people, it's not all that punitive. If you say, well, you can't vote, a lot of people don't care. But if you take away their amenity access, I find that actually sometimes, if you can control it, that can be useful, especially if you're in an HOA or a condo that has a lot of amenities. Maybe you have tennis courts or a clubhouse, a gym, a spa, a fitness center, all those sorts of things. If you can take those away, it does help. Now, when we talk about suspension of those use rights, the places you can suspend rights from are what I just discussed, and they're listed here. There are some things you can't take away just because someone owes a fine or some other money. And that is to these items here. Common areas used to provide access. That means you can't tell someone they can't use the lobby of the condominium if the lobby is where the elevator shafts are that they need to get up to their condo. The same goes for arguably, and this goes to means of ingress and egress, one of the most popular but controversial suspensions of use rights we see is turning off resident gate access. And I will tell you, it's very controversial, highly effective, but very controversial. And look, the argument we make for our clients that choose to do it is that the statute says we can't prohibit access and ingress and egress. It doesn't say we can't impair. And it used to say you can't impair, but it was changed years ago to say you can't prohibit. So to me, I think that opened up a window where you can arguably suspend those resident gate access rights so long as they can still go through the guest gate and get access. Now, as an analogy, in a condo, I once had a board member ask me, well, if an HOA can suspend the guest lane, which makes it easier for someone to get to their home, well, in a condominium, couldn't we do the same thing effectively and tell them that instead of using the elevators, that they have to take the stairs? And I thought that was a pretty good analogy, but I also don't think that would be upheld. I don't think, if someone lives on the 20th floor, that we could force them to say, well, you got to hit the steps because you can't use the elevator. So I do not think that you could suspend that. But it was an interesting thought. Other things you can't suspend when people owe fines or other money are utility services. Utility services are, of course, all the things we normally think of. and some associations pay for. Some associations pay everyone's water bill as part of the common expense. You can't turn off the water to their unit when they owe money. Some arbitrators have said that this includes cable television and internet. And I would say previously, 10 years ago, I would say, nah, those seem more like luxuries. But especially internet now, I believe that an association would have a difficult time. And I know some of the providers allow you to do it. I think an association would have a difficult time justifying legally shutting off someone's internet, especially now after COVID, where people are so dependent on it. A lot of people have their home phone is cellular or through the internet, or people don't even have home phones, so they depend on the internet a lot for work and for other necessities, and it's maybe for delivery of medicine or food or whatever. So I would caution against it, but just like I said about the turning off of resident gate access, turning off the internet or the television is highly effective. It gets a lot of people to come running to pay their bills, but again, it is highly controversial. And then, of course, vehicular and pedestrian access, and lit parking rights. I've had associations say, well, they owe us a fine. Can we take away their parking passes? And the answer is no. They still have to be able to park their vehicles. Of course, if voting rights have been suspended, that unit's not counted towards any purpose at all, and it lists all the items here. So you want to just be mindful of that. It doesn't hurt your voting, because sometimes, you need those votes to get to a certain percentage. And the way that the statute used to read was those people couldn't vote, but they were still counted in the total number of units. So if you're trying to get a 2/3 vote of 100 units and you have 10 people that can't vote, but you still need 2/3 of 100 instead of 2/3 of 90, some associations used to be a little reticent to suspend those people because they wanted their vote. Well, now, because you can take them out of the equation entirely, it doesn't hurt your ability to pass voting that you need members to vote on. And just a note here, since 2017 for condos, you can only suspend voting rights if they owe more than $1,000 in total, with fines, assessments, whatever. It has to be more than 90 days, which was always the case. But you also have to give them proof of the debt 30 days before you suspend voting. So the law holds the sanctity of voting to be more important than turning off amenities, because this doesn't apply to condo amenities. I am of the opinion that people probably care more about their amenities than their voting in a condo, with, I'm sure, some limited exception. But in any case, this is what the law says. Now, look, this is the most important slide of the entire presentation, because you can do all this fining process, but you are going to be met with many defenses that are legally viable if they're articulated properly and the facts support it. So you want to be prepared for them. The first one is selective enforcement. You remember at the beginning of this presentation, I said how important it was to have uniformity in your enforcement. Well, you want to make sure that you are violating anyone and everyone for the same issues of which you have knowledge. So the first thing I just said, sameness. So sometimes owners will come in and say, you're not treating me equally or fairly because my neighbor is illegally parking their car and you're sending me a violation about my dog. Well, the law says just because a neighbor or someone else violates some other issue, that is not a selective enforcement offense. So that's where we get to sameness. It needs to be apples to apples for an owner to really be able to have a selective enforcement offense. So when they come in pointing to some other unrelated, non-similar issue, not selective enforcement. Recency is another one. We once had in a 55 and over community, we were going after a owner who was letting their 35-year-old son live in the unit by himself, which was not allowed. And their lawyer pointed to something that they said, well, we have knowledge that 20 years ago, so-and-so was allowed to do the same thing. And the law will not allow something of that age to stand for selective enforcement. Yes, it was the same exact violation, but it was 20 years ago. So not recent enough under the applicable case law. So not selective enforcement. Finally, knowledge. You know, we've had owners come in and say, well, I know I built my patio too large and you found out about it, but my neighbor has an oversized patio too, and you can't come after me because you didn't go after them. Now, patios are usually in the back of the house, and the association may not have knowledge of it. So that owner that has the oversized patio of which the association is aware can't point to something that the association has no knowledge of as a reason for selective enforcement. So again, for you managers and owners, when you are confronted with people talking about selective enforcement, which is a buzzword a lot of owners like to use when they're confronted with violations and fines, you can go back to this list and see, is it apples to apples with this other violation they're saying exists somewhere else in the community? Is this other violation they're comparing their violation to recent, which is in the last few years? And did we as the association have knowledge of that other one? Now, some other issues and defenses, they're kind of related to each other, are waiver and statute of limitations. Waiver, a lot of times the owners will say, well, this has existed for a while and for a couple years, you didn't do anything about it. You've waived your right, or you're what's called stopped from pursuing the violation or fining me. And that legally is not going to be the case, and especially helpful if your documents have what we call a savings clause. And most governing documents do have that clause that says somewhere that the failure to enforce any provision does not constitute a waiver. And again, we call that a savings clause. Similar to what we just discussed, waiver, statute of limitations, but that's more significant. You have a 5-year statute of limitations in Florida to enforce breaches of the governing documents, meaning violations. If you're aware, we had one association recently where there were penetrations that owners made to the exterior of the building in a townhouse that they weren't allowed to do to drain a water filtration system. And that had existed for 10 years, and the association was well aware of it. Well, because we had known about it for more than 5 years, those owners, even though they were in violation, they did have a legitimate statute of limitations argument and a defense. Now, I will tell you probably the most significant defense that we see to violations and fines are procedural missteps. If I am a lawyer that we're defending an owner, the first thing I'm going to look for are, show me that you had a board meeting, that it was noticed. Show me the minutes of it. Show me that you sent the 14-day notice and that the notice had the information that the individual would need and that's required by statute. Show me that you had a committee meeting and that you have minutes of the committee meeting that upheld the fine. Show me that you sent the letter after the fine was upheld, notifying the individual that the fine was upheld. All of those things, if there's a mistake in the interim anywhere, those, as I said earlier, the case law says you have to strictly comply. If there's a mistake or a misstep, you're going to have a hard time justifying and maintaining your fine if it comes under attack. Now, look, a lot of these things I've said here today about what's required and the defenses, a lot of times associations are going with the flow. They've been doing their procedure for years and they say, well, we never heard of all this. And I can tell you, things may be going smoothly because no one questions it, but these are things to be very mindful of, because all it takes is that one, and it'll become a big issue and everyone becomes aware of it. So, I would say it's very important to follow the statute, to be mindful of these potential defenses, to be diligent in the action you're taking when you're doing these fines. And just keep in mind, though, that fines are not the end all and be all. And sometimes for purposes of actual compliance, you may need to escalate to other means of enforcement. So that is the presentation. Normally we have, when it's not 700 people, we can have more interaction. I see there's 99 people on the Q&A. I don't know, Ashley, I don't know how you want to handle. Do you want to go through any of these questions? How do you want to handle that?
Yeah, great. Thanks so much, Dan. So I did just go ahead and launch the poll. So if you do need to leave, you can go ahead and leave. We would really appreciate you taking that just to get your feedback on how we did today. As I did mention before, I will be emailing out the presentation, a link to the video recording, and I will be giving Dan the attendee list so he can get your CEU credits handled. Dan, it's up to you. I mean, we have until 1 o'clock. So if you want to do some questions, we can, but totally up to you. I'll leave the ball in your court.
I'll scroll through and I'll see if I can get answer some of these questions. The rules and regulations have to be filed with the county. There was a period of time from 2018 to 2021 that there's a glitch in the HOA statute where the answer was yes. The answer is that's been corrected. No, rules and regs do not have to be filed unless your governing documents specify that, which would be highly irregular. Do boards need to provide notice for committee meetings, or can they work with the committees in the background? There absolutely has to be notice of the meeting, just like any other, especially in a condo, there needs to be notice of the meeting because those meetings are open. Again, unless your documents specify differently, which would be fairly abnormal. But yes, there should be a posting of those minutes of a committee meeting occurring. Let's see. Can you send a violation to a homeowner two that are a nuisance because they are verbally abusive? Yes, but it has to amount to a real nuisance. It can't just be the association isn't the kindergarten teacher to enforce all disputes between residents. So it would have to be a real nuisance where probably multiple owners are being impacted. But otherwise, if it's two neighbors that don't get along, I usually counsel boards that those neighbors need to work it out between themselves. If it's just people that are disagreeable with one another. Let's see here. Would the violation finding steps bypass the finding committee hearing if there's an insufficient number of people? Would it go to the attorney? No, the attorney cannot sit as the finding committee. You have to have at least three people willing to serve on a finding committee, or you cannot find people. And I do not have as an attorney, me and my colleagues, we do not have the authority to sit in that position. One question: how much can we fine an owner? That's up to, I referenced that in the presentation. So I would just go back to the presentation to review that. Can the board of directors amend rules by board resolution? Yes, unless the documents say otherwise. The board can amend their own rules. If someone has a violation and they're fined the max $1,000, can they continue the violation forever? Well, no. You can fine them again. You can restart the violation process if the violation still persists and continue to hit them with more and more fines. But you do have to go each time through the full process. Now, I also mentioned earlier, sometimes fines don't get the compliance you're looking for. So in those instances, you would probably need to turn that matter over to the lawyer because the fines aren't doing the trick. The fines are good for deterrent, They're good for trying to get compliance, but sometimes, people just don't pay them and they don't comply. So you got to unfortunately go legal at that point. Can a compliance committee meeting be a closed meeting? Well, not necessarily closed. In an HOA, it may not have to be noticed. But in a condo, it absolutely has to be noticed unless the documents specifically say it doesn't have to be. But it's not closed. Closed meetings, meaning it's not open to the public, are only going to be if you're meeting with the association attorney as a board or you're discussing personnel. But a fining committee hearing is open to the members. In a condo, almost should be always, and often in an HOA. Again, it depends on your governing documents as to whether those are noticed and open with minutes taken. Let's see. One person asked if photos have to be time date stamped. It's beneficial if they are. The photos, if you're including them with the fine or the violation letter, it should be. That's definitely helpful. Does a verbal warning count as a formal warning? Yes and no. I mean, there's no requirement to give any warning. So whether it's verbal or written, I mean, I would recommend you do it in writing so that no one can refute that you gave them an opportunity, that you gave them a warning. An owner refuses to replace a patio screen. If the fining doesn't, what should you do? If it looks bad, well, if it's their obligation, they haven't done it, you need to get the lawyer involved to compel compliance. And if the fines, whether you've tried fines or not, it sounds like you're probably going to need to go that route. Let's see. Should the association send a violation notice to an owner or tenant? I prefer to deal with the owner. I would recommend you send it to the owner, rather than the tenant. The owner, as I said earlier, they're the one with the vested interest, and notify the owner, hey, your tenant is doing this behavior. But I would also probably send a copy to the tenant to try to get them to stop. You have to say the name or address of the violators, or you can say their account numbers. I would say anything you can use to identify them. So if you have an account number, a lot number, that's fine. What is the maximum fine that can be levied for many leasing violations? Well, if it's ongoing, if it's, more than 1 day at a time for an individual violation, you can go up to the 10-day max, and then you can start the process over. If they still are leasing the unit in violation, and do another 10 days and another 10 days, but you got to go through the process every time. Sorry, I'm going to be skipping over some of these. I can't answer them all. Let's see. Does statute 720 allow electronic notification? Not for the 14-day. Well, I may have to check that, but for previously, it did not allow for the owner to be sent their 14-day notice by electronic means. That there's other meeting notices and things like that. I'm looking at this. I'm going to look this up right now. Yeah, it looks like yeah, they did change the statute to say the owner can attend the hearing by electronic means, but I don't believe they changed the statute to say that they can get the mail. Oh wait, no, it does say, sorry. They can get the 14-day notice at their mailing address or the email address in the association's official records. So you can send them the 14-day notice by email. So that's a good thing. The 14 days are 14 calendar days, not 14 business days. The statute says 14 days notice. It does not say business or working days. So it is 14 calendar. Can you fine per day from the date of the notice's cure date, or is it daily from when the fine is approved? I believe if you can go back from when the fine originally occurred. If they don't cure it, you can run the clock, in my opinion, going backwards. Otherwise, if you have to wait to start running the clock on a fine until you get all the way to approval, they could be in violation all perpetually. And then the day before, after you've done all this work, then cure the violation and say, okay, well, now you can't fine me. I don't think that's the way it works. I recommend you can go back as far as when it originally started for purpose of counting the number of days. What can be done if there aren't enough volunteers for the committee? Nothing as far as fining. You cannot fine if you cannot form the committee. Our board members are allowed to attend the fining committee meeting. I've gotten this question before. In theory, yes, but I would strongly recommend against it because it creates a burden on the committee members. It's almost like having your mom or dad supervise you while you're playing with your friend or something like that. You can't really be yourself when the committee may be reticent and remiss to really vote how they feel on a fine if the board members who levied that fine are sitting there. So technically, yes, I think they have a legal right to be there, but I would always advise that the board members let the meetings happen and let the committee do their thing without the board members kind of being part of that at all. If a fining committee has 5 members, can the other 2 be board members? No, none of the members of the committee can be board members. Are there any limits on the number of people who are fining committee members? No, it's just got to be at least 3 who are present at the hearing. It can be 5, 7, it can be more. You don't need that many, but can be more. What happens if a board or management chooses not to enforce the rules? Well, then you start to run into problems, and you really start to put your covenants and your community at risk. You need to enforce the documents, and if the community is not enforcing them, the only way to do that is to file suit to compel them to enforce the documents. Because when people aren't being enforced against, and homes look bad, or condos, people are allowed to just do whatever they want, it lowers property values. So you need to be enforcing, even though you may not make you the most popular. The board and the association need to enforce. Can there be a fee as opposed to a fine? Well, and they say if the dog does its business in the lobby, besides the fine, can there be a cleanup fee? No, the cleanup fee is essentially a fine. What you can charge them is an actual expense. So for example, we've had people that crashed into the gate because they were piggybacking another driver and they damaged the gate. We fined them the $100, but we also sent them the invoice for the actual damage. So no, you can't make up another fee, but you can make people who cause damage pay the actual cost. Let's see what else here. Can a fine be sent to a collection agency? Sure, if you want to, you can do that. While it can't result in a lien, can it be included on the estoppel? Absolutely, and that's how you often will get these paid. Are you saying an association can put a lien if the fine is $1,000? Only in an HOA, yes, they could put a lien if the documents specify that liens are enforced like assessments. And there are a lot of HOA documents that say that. If your documents say that, and a particular violation accrues $1,000 max, that statutory number, you legally can lien for that. But only, you can't take different violations that are 100 for different things and add them up to 1,000. It has to be one violation that goes for multiple days and gets to the 1,000. We talked about some of these other ones about cable and internet. I talked about. Let's see what else here. We're running out of time. I'll do a couple more because we're running out of time here. How many years is recent for selective enforcement? I would say 5, and definitely not more than 10. One individual pointed out a good point. Selective enforcement is a defense, not an excuse. And that's absolutely true. It doesn't excuse what they've done. It doesn't mean that they're saying that what they've done is correct. It actually a lot of times means, hey, they acknowledge that they're in violation, but they nonetheless have a defense to enforcement. Let's see. Someone asked about the new law about the backyard. They said 6 feet. There's a new HOA law that says you can't enforce architectural restrictions on the backyard. Anything in the backyard that can't be seen from the adjacent lots. So if I want to store an ATV in my backyard, my HOA no longer can tell me you can't do that. If I want to build a fire pit in my backyard, my HOA no longer can tell me I can't do that. And in those examples, it's provided that my neighbors on either side cannot see on adjacent, behind, immediately behind, or next to, can't see it. Now, one of the glitches in that statute, it says it can't be seen. It doesn't say from ground level. So what I would argue, if I were the HOA still trying to enforce against that, if one of the neighbors can climb on a ladder or from their second story of their home can see into their neighbor's backyard and see that ATV parked there or see that fire pit that they built, well, doesn't that mean we can see it? We can still enforce it? I think the intention of this statute was really, is it visible at ground level? And I think that's how it'll be enforced. But again, yes, there is a new law there. So be mindful if you're an HOA and you're trying to enforce their backyard, you will need to determine if it's viewable or not, either from the frontage of the home or adjacent parcels. Let's see. The statute of limitations, where does it come from? That's from the statute. It's from statute 95.11. That's the statute of limitations for all causes of action in Florida, civil matters. And 5 years is the statute of limitations on contract actions. And your governing documents are considered under law contracts that each of you have with your association. So that's where the 5 years comes from. It does apply to condos, HOAs, and cooperatives. And then it looks like just some nice comments. Thank you. A lawyer getting nice compliments and comments. That's a rarity. I appreciate those. Do the letters need to go certified? No, they do not. Although it's a good idea to send them that way, but they don't have to. These regulations, someone asked, they apply to condos with less than 150 units. They apply to all condos. And I think we're going to call it there.
Thanks for watching. For more great educational content, click the subscribe button now.